All rise. Division 2 of the Court of Appeals of the State of Washington is now in session. Commissioner Carl Treble is presiding. Our first case on the August 6th, 2025 docket is a motion for discretionary review. Case number 61036-1, Department of Transportation v. Flatiron.
Good morning, everyone. Please have a seat. And counsel for petitioner, it looks like you're reserved 2 minutes for rebuttal, and you can proceed when you're ready.
May it please the court. My name is Gregory Martin, and I represent Flatiron Lane Joint Venture, FLJV for short, in this action involving the Washington State Department of Transportation. I want to begin these arguments by talking about why the motion should be granted, why the appeal should be taken. That the trial court committed obvious and probable error is evident from our filings, and I'll go through that in more detail in a moment. That the trial court's misunderstanding and misapplication of the standards associated with the summary judgment motions now permeates the case, and that is now evident by the second motion that we have pending and a third motion to be filed. There was another motion that WSDOT filed for summary judgment, and that was heard. That motion was granted, notwithstanding the thin nature of WSDOT's position and disputed material issues of fact. The reason the court should take this is, as Commissioner Crooks stated in his law review article, it would result in a tremendous waste of judicial resources to allow this case to proceed as it currently stands through a trial, only to come back in this position. Now, this is a large, complex project. It's a large, complex dispute. There are multifaceted issues. We have 2 years of pretrial discovery and proceedings before we get to a more than 1 month long trial itself. But the issues in this motion and the issue on appeal is straightforward. It comes down to what is the standard when assessing a motion for summary judgment. And as the Halley court stated, on summary judgment, the trial court may not weigh the evidence, assess credibility, consider the likelihood that the evidence will prove true, or otherwise resolve issues of material fact. That standard was not applied by the trial court. Instead, the trial court on her own made determinations of disputed issues of fact, particularly in this motion and in the coming motion.
So on the impracticability motion itself, are there not other claims remaining that will still proceed forward?
That's one of the issues of fact that the court missed. So impracticability doesn't deal with costs that have been incurred. Impracticability deals with avoiding costs to be incurred. The claims that are currently at issue under the terms of the contract are for breach of contract actions for costs that have been incurred. Impracticability seeks to avoid further costs on the project itself. There are 2 distinct and different remedies. The fact that we have different remedies does not preclude our ability to proceed with impracticability. That's one of the issues that the court improperly assessed and determined, was that because we have another set of remedies, the judge forced on us an election of remedies. That's not the court's choice, that's our choice. The claims are not duplicative. If we were to prevail on impracticability, those would not be duplicative of the claims associated with the breach of contract action for costs that had been incurred already. I understand, we appreciate that there are 2 steps that we have to demonstrate to be successful on this motion. Certainly we have to demonstrate that there is an error, but we also have to demonstrate what the effect of that error is in the immediacy of the issue. I want to start with the effect part first. If we look at and consider this as an obvious error, we are now going to engage in a useless trial that moots our claim for impracticability. There is no way to bring that back after an appeal. The project is done, the costs are incurred, it is over at that point in time. There is no ability to seek a discharge at that stage. It's mooted, it's ended.
I'm not sure I understand that. Are there not financial remedies available after the fact if it is resolved on an appeal later?
Under impracticability, no. Impracticability seeks a discharge of the obligations under the contract. It is not seeking costs for those, for that
I guess
discharge.
my point is, if you proceed forward and then later win on impracticability, would you not have a financial remedy for the costs that were incurred that shouldn't have been?
Not under impracticability, and not for all the costs that are being incurred that could be avoided by impracticability. So impracticability, we avoid all of the costs associated with the project.
Well, I understand you're saying you avoid them.
Yes.
If you win now.
Yes.
What I'm saying is if you win later
We don't
on appeal and you incurred some costs, it
We don't-
seems to me you have a remedy in being remunerated for those costs.
You don't necessarily recoup all of those costs. That is why we are pursuing the impracticability as well. We don't recoup all dollar for dollar all of the costs that we would otherwise incur. That is part of the function of the impracticability, is to avoid those costs. The second effect is, if we look at the probable error, is that we have currently, or had currently, the right to pursue again the opportunity for an early decision on our declaratory relief. Yes, the court, we sought a bifurcated trial. The court initially denied that. No discovery had taken place by that point in time. We were pursuing discovery. That was frustrated by WSDOT. We then have a motion for summary judgment.
So I'm sorry to interrupt, but we're short on time.
Sure.
2.3B2, we've learned from recent case law, requires an effect outside of the litigation. What you're describing to me sounds like an effect within the litigation. Is there anything that affects your client outside of the litigation?
It is comparable. There is a recent case, and it's the Shettenberg case, and I apologize, I can't remember the exact site, where the court dealt with a comparable situation where a statute of limitations effectively expired because of the way the court handled the determination of the dispute in that situation. And in that case, the court found that the second prong of 2.3B2 was met. So we have a similar scenario here as it relates to impracticability. Our ability to seek an early determination through the court system has been frustrated. We won't have the ability to bring that back later because the impracticability by that point in time will be moot. One of the other concepts that I think that WSDOT and the court conflates is impossibility versus impracticability. Impracticability is not impossibility. We're not saying we cannot complete the project. We're saying it's economically impractical to complete the project. Those are two distinct things. And the fitness case goes to a lease of a building, which was the essence of that contract. This case goes to a design-build project. The essence of what was frustrated is our ability to co-locate. I see my time has expired. Thank you.
All right, thank you, counsel. Counsel for respondent, you have 10 minutes, and you can proceed when you're ready.
Good morning, Commissioner. Sarah Wadsworth on behalf of WSDOT. First, I want to address the third motion that counsel just referenced. That is not before the court, and this motion for discretionary review needs to satisfy RAP 2.3 standards on its own. Discretionary review is disfavored, and there is a high bar to get review. Under RAP 2.3B1, obvious error is a high certainty of error, such as failing to follow statute or clear precedent. RAP 2.3B2, probable error, is error a bit less certain, but has to have harm and impact outside of the litigation. FLJV has not met either of these standards. Focusing on the effects prong first, FLJV completely fails to establish either of the effect prongs under RAP 2.3B1 or B2. First, under B1, the trial court's ruling dismissing one of FLJV's many claims in this lawsuit does not render further proceedings useless. If FLJV is successful on its other counterclaims, FLJV's 30B6 witness has confirmed that it will be made whole. That is not a useless proceeding. And second, under B2, the ruling did not alter the status quo. FLJV fails to point to any effects outside of this litigation beyond it wanting a remedy of setting aside the contract. But losing a remedy based on the summary dismissal of its claim in this litigation is not an effect outside of the litigation. It is squarely within the litigation. Second, focusing on the error prong, the trial court's grant of summary judgment on FLJV's claim for impracticability is not obvious or probable error. It's not error at all. The court applied the well-established summary judgment standard to the facts of this case under established precedent and found no genuine issue of material fact. Impracticability only applies if a basic assumption of the contract is destroyed, rendering performance impossible or impracticable. This can occur when performance is so vitally different from what the parties expected that the essential nature of the performance is different.
So there was a deposition stating that there was an opinion, I don't believe the job is impossible. And I see that evidence. Is there evidence going to impracticability versus impossibility?
Yes, the FLJV has confirmed and admitted that it continues to perform under the contract. It continues to perform to this day. It continues to get paid for the work that it performs to this day. There is no genuine issue of material fact about that. And the trial court properly emphasized that the FLJV has also admitted that there's no portion of the work that it cannot perform. And it has admitted that the work is possible and that it has no intention of stopping work. There's no dispute that the fundamental purpose of the project, the construction and improvement of I-405 from Renton to Bellevue, is continuing and in progress. Additionally, FLJV is making counterclaims under this contract. The contract meticulously allocates risk between the parties. It sets out FLJV's responsibility and risk for designing and building the project at a fixed price. And it sets out that FLJV has responsibility to reach substantial completion of the work by a specific contract time. And importantly, the contract has a detailed and comprehensive dispute resolution process which FLJV must follow in order to make claims for additional time and money. The contract has contemplated claims for additional time and money and specifically outlined how FLJV must proceed in order to request that time and money. There is no dispute that FLJV is pursuing claims against WashDOT in this litigation under the contract. FLJV has admitted that if it's successful with these claims, it will be made whole and fully compensated. And that's at Appendix 225. Those are the undisputed facts. That wasn't what was in front of the trial court. That FLJV is performing the work under the contract to this day. They're getting paid under the contract to this day. The contract meticulously and comprehensively outlines the risk for claims for additional time and money. And FLJV is, in fact, pursuing claims for additional time and money.
So, counsel, as you noted, this third motion that was referred to is not currently before this court as part of these motions for discretionary review that we're arguing this morning. But is there, I don't know anything about them, is there a chance that that third motion is going to moot these two motions or not?
No. FLJV has many claims in this litigation. And yes, there is motion practice on multiple claims. It's a large case with many claims. But this claim is separate, largely focused on COVID. That one is not related to COVID. So again, would not move this motion for discretionary review.
Thank you.
And again, this is not a case like Smuggler's Cove where an essential fundamental purpose or assumption of the contract that a boat actually existed was destroyed. Instead, we have a situation where FLJV claims that their performance of the contract has become more expensive and more burdensome. But we have recent Washington Court of Appeals precedent that's directly on point on this issue, which says that just because COVID may have made a performance of a contract more difficult or expensive, that doesn't make it impracticable. And that's the Fitness International case. And there, as a matter of law, the court said that COVID did not make the performance of a lease impracticable, even though the gym operator could no longer operate a gym within the facility. Because Fitness International had the exclusive right to still use the premises, it was not discharged of its responsibilities under the lease. And the same is true here. Even if COVID made FLJV's performance more difficult or burdensome, it's undisputed that FLJV continues to perform all portions of the work and get paid. The trial court followed Washington precedent, which is not obvious or probable error. Review is not warranted. Thank you.
All right, thank you, counsel. Counsel for petitioner, you've got 2 minutes remaining for rebuttal, and you can proceed when you're ready.
Thank you. So both WASDOT and the trial court have made a determination of material fact when they say the fundamental purpose of this contract is to build the job. That is a purpose. It is not the fundamental or underlying purpose that led FLJV to bid and propose on this project, to decide to compete for this work. The undisputed position from FLJV's declarations is that the underlying assumption for this contract, co-location, to be able to design the project timely, quickly, to meet the dates associated with it at the price proposed, was destroyed by COVID. They could not co-locate. That is underlying this entire design build project. That's what the court and WASDOT have ignored. That is a fundamental fact that is at least disputed in this case.
So if it's impracticable, why is it still going forward?
Because it's not impossible. It's not impossible to continue to design. It takes longer. It's impractical. It was made impractical to design timely because they could not meet in person. They could not do things side by side. They could not work through this process more quickly. We're not saying that the project cannot be designed, cannot be built. But as WASDOT says, the project is years late because they could not co-locate. That was a fundamental assumption in this contract that the trial court has ignored and made a determination of fact. That's why her decision should be overturned. Thank you.
All right, thank you, counsel. And that matter will be taken under advisement, and the court will be ready for next arguments involving the same parties as soon as we reset everything. Exactly.